Assalamualaikum warahmatullahi wabarakatuh. Very good day to everyone. Okay, for today we will discuss topic 12, which is on occupiers liability. Yeah. Basically, this topic is about the liability of an occupier of premises. Okay, in cases where there is injury to person who enter the premise. Okay. And the injury that happened, it might be because the premise is not safe ataupun because of the failure of the occupier untuk take reasonable steps untuk ensure that the premise is safe, ataupun because of the failure of the occupier untuk warn about the danger to the entrance. Okay, so if you read textbook, especially the old textbook, you'll see the historical part of this rule. You'll see that the law on occupiers liability ni adalah dia emerge at the same time when negligence emerge, and previously it was considered as a separate tort. Okay, but we will not discuss about the historical part of this law. But you need to know that in the UK, in the law in England, they have specific act on this. First, they have Occupiers Liability Act 1957 and also Occupiers Liability Act 1984. Okay, but in Malaysia, the law in Malaysia, we don't have any specific act that relates on occupiers liability. Okay, because of that, the law in Malaysia on occupiers liability is mostly based on common law of England. Okay, and this is stated in the case of Sri Inai, Sri Berhad again Yonggit Sri. Okay. Dalam kes ini, the case of Sri Inai, the court referred to Section 3 of the Civil Law Act 1956. So the court said that cases on occupiers liability, it will be under the tort of negligence. Maksudnya, negligence claim for occupiers liability, it will be based on the standard of care required of the occupier, i.e. the defendant in any cases, in any cases involving occupiers liability matters. Okay, and the plaintiff, i.e. the person yang enter the premise, who we call entrance, they need to prove all the elements of negligence. So he needs to prove the existence of a duty of care, breach of the duty of care, i.e. the standard of care and also causations. Okay, so now what you need to know is that for this topic, we will discuss few things. Okay, few things that we will discuss, the important parts. We will only discuss the important parts. We will look at who is an occupier, and then we will look at what can be considered as premises, and then who are the entrants. And after we discuss about who are the entrants, and then we will look at what are the duty of care that is owed by the occupier to those entrants. Okay, and then we will look at some of the defenses available for the occupier. Okay, so these are the main discussion for topic 12. All right. Okay. The first one, as I've mentioned, we will discuss about who is an occupier. First, we need to determine who is the person that we can consider as an occupier. Okay. So, to prove any case, kita kena buktikan, kita kena determine who is the occupier first. Okay. So, as you guys can see from the meaning here, an occupier is the person who controls the premises. They do not have to be the physical occupier nor the owner. The critical issue is whether they exercise a sufficient degree of control to allow or prevent other people entering. In each case, whether this level of control is exercised will be a question of fact. So maksudnya occupier ni adalah person yang ada sufficient ada sufficient degree of control over the premise, any premise. Okay, and because he has control over the premise, he has a duty of care towards siapa-siapa yang enter into the premise. Okay, so the court akan determine sama ada that person who has the sufficient degree of control, i.e. the occupier, by looking at the facts of the case. Because as mentioned, this is a question of fact. Maksudnya mahkamah akan tentukan apa duty of care owed by that person who has sufficient degree of control. Okay. And the test that will be used untuk determine siapa occupier is what we call the occupational control test. Okay, occupational control test. Dan case yang discuss tentang occupational control test is the case of Witt against Laken. This case, yeah. This case discussed about occupational control test, the test that we can use to determine who is the occupier, yeah. So dalam case ini, in this case, if you read the facts of this case, the claimant stayed at a public house owned by the defendants, yeah. And then her husband fell down the stairs and then died because of the severe head injuries. And the fact also showed that the stairs dalam public house tu, the stairs was steep, yeah, was steep, narrow, and the handrail stopped at 2 steps from the bottom of the stairs, yeah. So there was in addition there was no sufficient lighting there. Okay, so dalam case ini, if you baca this case, the judge in this case state that, look at the judge in this case, Lord Denny, yeah, held as follows, yeah. Whenever a person has a sufficient degree of control over premises, that he ought to realize that any failure on his part to use care may result in injury to a person coming lawfully there, then he is an occupier. So, kita boleh cakap once it is established yang a person ada sufficient control over the premise, we can say that he is deemed to be the occupier. Okay, person who has a sufficient degree of control over premise. Okay, and then once he is deemed to be an occupier, we can sue him, we can bring an action against him for any injury sustained di premise tersebut. Okay, alright. But another thing that you need to remember is tak ada requirement for physical occupation of the premises. Okay, actual possession is not required in determining the adequacy of sufficient control. For this point, you can refer to the case of Harris. Okay, this case. Dalam case ini, if you baca the facts of this case, the court held that actual physical occupation was not required to incur liability as an occupier. Okay, alright. So, from this discussion, we can say that there will be no problem, yeah, if the owner of the premise is in what we call in physical occupation of the premise. Okay, no problem. So it's easy to determine who is the occupier in this situation. But the problem to determine the occupier, it might arise if the person other than the owner occupy the premise. Okay, occupy the premise or be at the premise, yeah. So in this kind of situation, we'll use the what we call occupational control test, as discussed in the previous case of Witt Laken, yeah, Witt against Laken. So liability, it will be imposed on those yang ada control of the premise, sufficient degree of control of the premise, yeah. And liability, it will be imposed on those who have control of the premise. So it seems that the important thing to look at is the occupation, yeah, the occupier, who's the occupier, and then the possession and or control, not the ownership. Yeah, the ownership is not important matter to decide whether a person or an individual is an occupier or not. Okay, all right. Now, after we already discussed about the first subtopic, which is about the occupier, we will look at the premise. What is premise? Premises. Apa itu premises, yeah? So you can refer to the case of Lautin C, yeah? Before that, you see here that as you guys can see from the slide here, okay, There is no definition of the word premises in the Occupiers Liability Act 1957. Okay, thus it is necessary to turn to the common law for guidance. Okay, so the common law we refer to case, and one of the Malaysian case is what we call the case of Lautin C. Where in this case, if you read, okay, the court in this case stated that the word premises, it might include all forms of buildings, land spaces, vehicles, which are used for carrying person, or structures, even structures, we can call it as premise, such as ladders and scaffolding and etc. Okay, so this is what is premises, what is premises, the meaning, we can refer to this case of Lautin C. So if there's a question, you want to determine the premise, you can refer to the case of Lautin C. Okay. You can also refer to the case of Wheeler, where in this case, plaintiff used a ladder. Okay, used a ladder that the defendant lent to him, and then the ladder broke, and then he was injured because of the ladder. So the court concluded, the court in this case, they included ladder as a premise. And because of that, after discussing and after looking at all the evidence, the court held that the defendant was liable in negligence in this case, the case of Wheeler. Okay, all right. So we already discussed about occupier, who is occupier, who can we consider as an occupier, and then we'll discuss about premises, the meaning as stated in the case of Lautin C, and you guys can also refer to other cases, especially the case of Wheeler and etc. Okay. Now, the important part. This is the important part of the discussion, which is about the 4 categories of entrance. We will look at who are the entrants, who can we consider as entrants, and after we consider discussing about who the entrants, we will look at we need to know the categories of entrants. Why? Because we need to know the standard of care required of them. Okay, kita kena tahu Jadi you need to know that occupier owes a duty of care to 4 categories of entrants. These are some of the categories. We have contractual entrants, we have invitees, licensees, and also okay. And as mentioned here, the standard of care required of the occupiers, okay, of each this of the occupiers, it will be different. It differs according to the type of entrance. All this type of entrance all have a different standard of care required of them. If you read articles or any textbook, it seems that the occupier owes highest duty of care towards contractual entrance. Okay, so the standard of care for each entrance, each standard of care of the occupier will be different according to the different types of entrance. So occupiers akan owe a higher standard duty of care, a higher duty of care towards contractual entrance. Okay, because why? Because there's the existence of a contract between them. Okay, meaning the standard of care required of the occupier is higher compared to cases involving other entrants. Okay, and then the second highest is towards invitees, because of the mutual interest, the existence of mutual interest between the occupier and also the invitees. Okay, and next, the duty of care towards licensee is lower compared to duty of care owed towards contractual entrance and invitees, lebih lesser compared to contractual entrance and also like invitees, because licensees ni, they are the person who gets permission only to enter the premise for their own purposes. Okay, and lastly, a lesser duty of care owed towards a trespasser. Okay, ini paling rendah lah. The occupier owes the lowest duty of care towards the trespasser. Why? Because use our common sense, because he is a trespasser, the person is a trespasser, so he trespass the premise. Jadi it's logical to say that the occupier owes a lower duty of care, owes a lesser duty of care towards the trespasser compared to contractual entrance, invitees, and also licenses. Okay, all right. So the first point that we will discuss is about contractual entrance. This is the first type of entrance, yeah, what we call contractual entrance. Maksudnya a person who is on the premise pursuant to a contractual right, like the name said, yeah, contractual entrance. So they are the person who enter premises by virtue of a contract. Okay, they are the one who pays to enter the premise. For example, ya, contohnya macam guest dekat hotel and etc. They have a contract to enter into the premise. Okay, and then you need to know that an occupier, they the occupier owes a duty of care, a duty untuk make sure that the premise is safe. Okay, the premise is safe for the purpose the contractual entrance enter the premise. Maksudnya, occupiers ni owes duty of care as stated in the contract between them. Contohnya jika, meaning if the purpose is to stay at the premise, yeah, then the occupier has a duty to ensure that the premise is safe for the occupants, the person who, the entrance, the contractual entrance. Contohnya macam guest in a hotel, maksudnya occupier, the owner of the hotel needs to ensure that the room is safe for the guest, for the guest who is the contractual entrance, yeah. Okay, and then there are two types of contractual entrance. We can further divide it to main purpose entrance and also ancillary purpose entrance. Okay, the first one, what we call as main purpose entrance, a person who enters the premises for the purpose of occupying it, who has paid to be on the premises, such as tenant or a guest in a hotel. Jadi a person who entered the premise for the purpose of occupying it, staying in it. Okay, maksudnya untuk stay at the premise. Contoh macam yang diberikan adalah tenant ataupun a guest in a hotel. Okay, jadi dia ada bayar lease ataupun ada membuat certain bayaran, ya, untuk stay in the house ataupun the hotel. Okay, so as I mentioned, the occupier has a duty untuk ensure that the premise is safe. Premise is safe and adequate for that purpose of entry. Okay, maksudnya perlu make sure that the premise is safe from any danger, any possible danger. Okay. And the case, you can refer to the case of Matt Lennon. Okay, this case. Dalam kes ini, if you baca dia punya facts, there was a fire, fire at the defendant's hotel and the plaintiff was injured dalam kes ini. And the court held that the defendant was liable. Why? Because of the defendant's failure to ensure that the premise was safe. Okay, kenapa mahkamah putuskan macam terdapatnya failure untuk ensure that the premise was safe? Because mahkamah, based on the facts, mahkamah dapat lihat bukti bahawa there was no emergency way out in the hotel. Okay, tak ada emergency, tak ada laluan kecemasan. Okay, so the defendant dalam kes ini was liable, and dalam kes ini the plaintiff was the main purpose entrance, because the plaintiff dalam kes ini paid untuk stay at the defendant's hotel. So the defendant was under the duty to ensure that the hotel was safe for all guests. Okay, and because the defendant failed to do that, by failing to provide emergency exit in the hotel, because of that failure, the defendant was held as liable. Okay, all right. And then the second one, we have ancillary purpose entrance. So it's unlike main purpose entrance, so ancillary purpose entrance ni adalah person yang pay untuk enter the premises for other purpose than occupying it. Dia bukan nak occupy the premise, contohnya adalah person who pay untuk enter cinema, a cinema to watch a movie, ataupun person yang pergi ke private hospital untuk dapatkan treatment. So dalam situasi macam ni, um, the occupier has a duty to ensure that the premises are safe for that particular purpose. Okay. How? By using necessary skills ataupun precautions ya untuk make sure ya premise ni adalah safe untuk that specific purpose. Okay. So maksudnya kalau contohnya occupier of the cinema, owner of the cinema, they need to make sure that the cinema is safe kepada semua customer who pay to watch a movie. Contohnya ya, contohnya dia kena ada emergency exit and then other precaution done, kena check sama ada tak ada benda-benda berbahaya dekat cinema tu ya. Similarly untuk patient untuk private hospital juga, they need to ensure that the premise is safe for all their patients, something like that. Okay. All right. So you can refer to many cases. For example, the case of Hall, the case of Gilmore. Ya, kalau you baca the case of Gilmore dalam case ini, the plaintiff dalam case Gilmore ni, the plaintiff fell during exercise class. Okay, so dia enter into that premise untuk exercise tapi dia jatuh sebab the floor was slippery. The floor was slippery ya. So she successfully claimed against the defendant. Why? Because the failure of the defendant untuk make sure that the floor was suitable for physical exercise ya. Because dalam kes ini plaintiff ni she paid to enter the premise for exercise. Okay, jadi kita nak exercise. So she was an ancillary purpose entrant. Okay. Therefore, the defendant had a duty untuk ensure that the premise adalah safe untuk exercising. Okay, jadi dia kena make sure yang the floor was not slippery ya, sebab kita nak guna untuk dancing. Jadi floor ni kita mestilah pastikan tak licin. Tapi dalam kes ini the defendant fail untuk act according to the standard of care required. Why? Because the defendant failed to ensure that the floor was suitable untuk physical exercise. Yeah. So the court allowed the plaintiff claims against the defendant dalam kes ini. Okay. So we can say that based on our discussion on this first type of entrant, we can say that an occupier, they owes a duty of care towards an entrant, towards a contractual entrant who enter into his premise either with the intention of occupying it ataupun for any other purpose. Jadi memang ada owes a duty of care. And the duty of care, the occupier kena make sure yang the premise is safe for that particular purpose. Maksudnya tak ada danger, meaning no danger. He must make sure that there's no danger, but not necessarily every possible danger. Okay. Jadi itu adalah standard of care required of an occupier towards the contractual entrance, which we divide to main purpose entrance and also ancillary purpose entrance. Okay, right. So that's the first one. The second one is the second entrant is what we call invitees. Okay, invitees. Yeah. As you can see from here, a person who enters premises with the permission or an authority of the occupier. Usually the purpose of entry is a matter of common interest between the occupier and the invitee. Okay. Maksudnya invitee ni adalah person yang enter dengan permission ataupun invitation. Okay. Purpose selalunya for economic benefits lah. For common interest with the occupier. Okay. Contohnya adalah kita katakan A, a customer going into a shop owned by B untuk buy certain goods, yeah. So A enter the premise after looking at the display of goods at the shop. Okay, jadi ada invitation to trade lah, invitation untuk display of goods ni adalah invitation to trade untuk inviting A or any other customers untuk enter the shop. Okay, and to purchase the goods in that shop, yeah. So that's one example. Other example, for example, policeman, fireman, and etc. Yeah. Okay. So dalam case ini, dalam this entrant, yeah, we can see that the important elements are the word invitation, and also material interest to the occupier. Material interest ni it can be it is the factor yang differentiate between invitees and also licenses which we will discuss later. Yeah, so because most of the time the interest will be financial lah, financial or pecuniary. Yeah, but in some cases, although not many, the interest was not financial. Okay, was not financial. Okay, all right. So another thing that you need to know, occupier ni akan owes the duty of care towards invitees. Dia ada duty untuk use reasonable care untuk prevent any damage ataupun injury from unusual danger that he knows ataupun ought to know. Okay. And the invitee does not have the knowledge of the unusual danger, the existence of the unusual danger. So back to the example that I've given just now, katakan B, B, the occupier of the shop, needs to exercise reasonable care untuk prevent any injuries ataupun damage kepada A, who is the invitee. Jadi A kena make sure yang there is no unusual danger in that shop. Okay. And then we can further divide invitees to three categories. We have legally authorized entrants, business visitors, and also public invitees. Okay, public invitees. Okay. First, legally authorized entrants. Who? They are the person who enter premises on the authority of the law, such as policemen, firemen, meter readers, or health inspectors. Yeah. So they are the person who enter premise with the authority of the law. Okay. Contohnya, you boleh baca the case of Samsudin. Dalam case ini, kalau you baca case ini, the court held that the police yang enter into the premise was considered as an invitee. They are the legally authorized entrants. And because of that, the occupier, they has a duty to ensure that the premise ni, the premise was safe untuk avoid any injuries to the police. Okay. Alright. And then we have business visitors. Okay, business visitors. This is one of the category of invitees, yeah, invitees. So business visitors ni adalah basically person who enter for economic purpose. So person who enter premises, be it public or private, for a materialistic reason, and who actually bring economic advantage to the occupier, such as a customer at a supermarket, a guest at a hotel, a motorist at a petrol station, a customer at a bank, or an employee at his workplace. Okay. Jadi, occupier has a duty to ensure that there is no danger which is known to him or ought to be known by him exists in that premise. You look at here, standard of care required, and occupier has a duty to ensure that any danger which is known to him or ought to be known by him and which the visitor is ignorant of is averted. Okay. For this point, you guys can refer to the case of Indemore. Dalam case ini, please read the facts of the case, but dalam case ini, basically the court stated that an occupier must reasonably avoid any damage yang boleh arise daripada unusual danger or extraordinary danger that is known to him ataupun ought to have been known to him. Okay, kalau you baca dalam facts case ini, the extraordinary danger or the unusual danger was gas heater fell when the plaintiff tried to fix the gas pipe, fix the gas pipe at the defendant's premise lah, i.e. the factory. So the court held that dalam case ini, this unusual danger was known to the defendant. So jadi the rule is that an occupier owes a duty of care towards business visitors. The duty is to ensure that there is no danger which is known to him or ought to be known by him exists in that premise. So dalam case ini, the defendant did owe a duty of care towards the plaintiff. Okay, and did owe because the defendant dalam case ini knew the existence, the unusual danger was known to the defendant. Okay, all right. So this is about business visitors. Lastly, about public invitees, public invitees, who are the person who go to public park ataupun public places, public places, and then this is also one of the category of an invitee, an invitee dalam kes ini juga, ya. Okay, jadi these are the three types of invitees. So if you read there's one case, hold on, let me find the case. There's one case, if I'm not the case of Lautin C, the case just now, the case that we discussed about premises just now. If you read the case of Lautin C, dalam kes ini mahkamah kata the duty of an occupier to an invitee is untuk use reasonable care untuk prevent damage ataupun injury from unusual danger that he knows ataupun ought to know. So this is the standard of care, standard the duty of care owed by an occupier to an invitee. Okay. The next question is, what are the factors? What are the factors that need to be considered for an occupier to be held liable to an invitee? Okay, apa faktor yang perlu diconsider jika for an occupier to be held liable to an invitee yang suffer injuries ataupun suffer any damage to his property? So the factors that the court will take into consideration are, number one, if the occupier knows or ought to have known of the danger. Okay. Number two, the danger is unusual. Number three, the danger is not known to the plaintiff. And number four, the occupier has failed to reasonably avoid the damage from occurring. Okay, so all of these are the factors that the court will take into consideration in deciding for an whether an occupier to be held liable to an invitee yang suffer injuries ataupun tidak, ya. And all these factors are basically discussed in the case of Indemore, Indemore just now that I've mentioned just now, the case of Indemore. Okay, all right. Okay, so we will look at every factor, The first factor is about basically it's about the occupier's knowledge. Maksudnya mahkamah, they will consider whether the occupier ni knows or ought to know about the existence of the danger. Okay, whether he knows ataupun he ought to know about the existence of the danger in the premise, So if yes, if he knows or he ought to know about the existence of a danger, he is considered as owing the duty of care towards the invitee who entered into his premise. Okay, macam mana mahkamah akan determine that the occupier is he ought to know about the danger? Macam mana mahkamah akan tentukan? It is if, let's say, if other reasonable men would know the existence of a danger. Okay, if other reasonable men who is put in the same position, they will know about the danger ataupun tidak. Jadi if other reasonable men who is put in the same position would know about the existence of the danger, then the court will consider the occupier must know about the danger. He ought to know about the danger. Okay. For this one, you can refer to the case of Hawkins. Dalam kes ni, you baca, Lord Dennis stated that if the occupier knows of the physical condition of the premises and a reasonable man would know that it is dangerous, then the occupier is deemed to know of the danger. In these circumstances, he owes a duty to warn an invitee unless the danger is obvious. Okay? All right. Okay. That's the first factor, the first point. The second factor that the court will take into consideration for to determine for whether an occupier to be held liable ataupun tidak to an invitee is whether the danger is unusual ataupun tidak. Okay. As you guys can see here, what constitutes unusual danger is a question of fact and depends on the degree of danger in each case. Furthermore, what is unusual danger at one time or place may be usual at another time in another place. Maksudnya the court akan decide sama ada the danger itu adalah unusual ataupun tidak by looking at the facts and circumstances of the case. So we can say that that danger, that unusual danger ni, like the word unusual itself, it means something that will not usually happen. Okay, it will not usually happen. Okay, so if you read the case of London Graving Dock Company, kalau you baca case ni, the court held that an unusual or extraordinary danger adalah danger, the thing that is not common. Okay, the thing that is not common for the purpose of that particular person, particular invitee. Yeah? So you can read this case for better understanding of this second factor. Yeah, and the third factor is what we call the knowledge of the plaintiff. Okay, jadi the court, they will determine if the danger is not known to the plaintiff. Okay, so if the danger is not known, unknown to the plaintiff, then the conclusion that can be made is that the danger is unusual. Okay, so if the danger is known, we can presume that the danger is usual, a usual danger. Okay, so in a simple word, we can say that if the plaintiff, i.e. the invitees, the invitee, they knows about the danger, and in this situation, the occupier owes no duty of care towards him. Okay, for this one, you can refer to the case of London Graving Dock, where dalam case ini, a welder whose claim for injuries sustained due to defective staging by the occupier was denied as he was held to be aware of the danger. He has a knowledge of the danger. Okay, because if the danger is known, we can presume that the danger is usual. So bila the danger is usual, we can say that if the plaintiff, when the danger is usual, meaning the plaintiff or the invitee, they knows about the danger. Okay, so because the plaintiff know about the existence of the danger, then the occupier owes no duty of care towards him. Okay, all right. And lastly, the last point is that the occupier must have failed to avoid the injuries or damage from happening. So this point is very easy to understand. So we can say that these are all the factors that need to be considered for an occupier to be held liable to an invitee, okay, who suffered injuries ataupun damage to his property. Yeah. So to understand better on this case, on this point, you can also refer to another case, the case of this case, the case of Takung Tabari, Takung Tabari. Kalau you baca case ini it's quite lengthy, the facts. If you read this case, but basically the case, the deceased in this case was a customer in the premise of the public bank, the public bank. So dalam kes ini public bank ni adalah the fault defendant, okay, the fault defendant. So dalam kes ni, the deceased died because of the explosion and because of the fire that happened because ada gas leak, ada kebocoran gas dekat premises occupied by the bank. So the supply of gas was under the management of the government of Sarawak, okay, which was the first defendant in this case. And then the court in this case held that the deceased was an invitee. Okay, so the occupier, i.e. the bank, owed a duty untuk prevent any damage ataupun any injury that happened because of unusual danger that he owes ataupun ought to know. So dalam kes ini, the deceased was the bank customer, so he was an invitee, and the bank was the occupier. So the court held that all the defendants were liable. Okay, dalam kes, kalau you baca kes ini, the defendants were liable. Kenapa? First, because the bank knew, or ought to have known the danger of the explosion and fire. Kenapa? Kerana selepas meneliti bukti, fakta dan circumstances, the court said that the fact stated that there was already ada smell, ada bau gas leak dekat bank tu selama a month before the explosion happened. Dah lama, dah sebulan dah berbau gas leaking tu. Jadi the bank ni dia tahu, then dia supposed to tahu the danger of the explosion. Okay. Second, because the danger, i.e. the explosion, it was unusual to the deceased. Kenapa? Because the deceased ni was merely a customer of bank. Jadi explosion itself, it was unusual danger. It's not usually happen at the bank. Tak selalunya berlaku. It was unusual danger. Okay. And then number 3, the danger was not known to the deceased. Because as I've mentioned, the deceased ni adalah customer of the bank. Jadi customer dia takkan expect akan find a dangerous thing, like the gas leaking yang akan cause explosion and fire in the bank. Okay, so the danger was not known to the deceased. Yeah. And lastly, kenapa mahkamah putuskan bahawa defendants were liable? Because the bank, who was the occupier, telah fail untuk reasonably avoid the damage from happening, the injury from happening, because fact shows that even though they smell the gas leak, they did not take any precautions ataupun measures. Dia tak pergi check apa yang happen sebenarnya or whatsoever. Okay, so it fulfilled all the 4 factors that we've discussed just now, and that was why the defendants dalam kes ini all were held as liable. Okay, so based on all this discussion, we can conclude that an occupier owes a duty of care to an invitee also. Okay, and the duty is to use reasonable care untuk prevent any damage ataupun injury from unusual danger that he knows ataupun ought to know. So this is the standard of care required of an occupier towards an invitee. Okay, all right. Next one, the next entrant that we will discuss about on licensees. Okay, licensee. Yeah. So we already discussed the first 2 types of entrants. The third one is licensees. Okay, as you guys can see here, a person who entered the premises with the occupier's gratuitous permission, be it express or implied. Usually, the occupier does not have any interest in the presence of the licensee on his premises, unlike a contractual entrant and invitee. Okay, jadi maksudnya a licensee ni adalah person yang enter the premises dengan express or implied permission of the occupier, tapi bukan untuk any benefits or any material interest with the occupier. They don't have any material interest with the occupier. Okay, jadi the difference between invitees dan juga licensees is the requirement of material interest. Okay, kalau dalam licensees tadi yang kita bincang, in licensees ni yang kita akan bincang ni, tak ada element of material interest. Contohnya, katakan A enters into B's house. Kata selepas A ni, B invited to have a dinner together. Jadi A dalam situasi ni, A adalah licensee, i.e. the social visitor, ya. And B is the occupier. So A ni enters the premise after getting invitation. Okay, and then tak ada sebarang other any material interest at all, just for social gathering, social visitor. Yeah, so that's the example. Okay, and then you need to know that in cases involving a licensee, occupier ni tak ada duty untuk ensure that the premise is safe, tapi the duty is ada duty untuk kena warn the licensees of any concealed danger that he actually knew ataupun ought to have known. Okay, maksudnya licensees ni mereka kena need to be protected daripada any danger, any concealed danger yang occupier knew ataupun ought to have known. Okay, and then the licensee himself, he does not know about the danger because it is a concealed danger, yeah. So maksudnya there should be no concealed danger in the premise. Okay. Again, there are three types of licensees. We have entrance as of right, social visitors, and also entrance by implied permission. Yeah. Okay. The first one is entrance as of right. Who are they? They are those who have the right to enter into premises that are open to the public, such as public park, public lavatory, public library, public swimming pool, and other building open to the public. Ya, jadi maksudnya kita boleh katakan entrance as of right ni adalah mereka yang ada right untuk enter premises that are open to public. The premises are actually open to the public. Okay, they can enter it, you know, contohnya macam person who enter public library, something like that, ya. Jadi in this situation, occupier ni kena ensure and take reasonable steps untuk avoid any damage from occurring, ya. And then you might ask, okay, after all discussion, yeah, whether an entrant as of right is to be treated as a licensee or an invitee. Okay. Kalau you baca kat sini, in Australia, the duty owed to the person who makes use of public facilities is deemed to be higher than duty owed to mere licensee. The principle seems to be that if the occupier neglects to carry out inspection for purposes of discovering whether his premises is safe for the public, with the consequence that a member of the public is injured due to the danger arising from the dangerous state of affairs on the premises, then the occupier is said to have failed to exercise reasonable care to avoid the damage, and so he will be liable. Jadi kita boleh katakan kat sini, entrance as of right ni is entitled untuk those who entrance as of right, they are the one who entitled untuk expect yang the premise is safe for all, is safe to all public. Okay, so that's on apa to entrance as of right, yeah. And then social visitors, they are the person who enter the premise with the permission ataupun invitation, okay, of the occupier, and not for any advantages, any financial purpose or whatsoever. Yeah? It's purely social in nature, social reason. Social reason, ya, social reason. Contohnya macam apa yang saya berikan sebelum tadi, your friend comes to your house untuk for dinner, something like that, ya. So dalam kes ini you boleh refer kepada kes Yap Cheng Hock. Okay, dalam kes ini, the plaintiff who was a geologist was injured during a visit, yeah, a visit to mine. The visit being for his own purposes, and his visit was not meant to bring any benefit to the defendant occupier. Okay, jadi dalam kes ini, the judge stated that at common law, a licensee is a person who enters premises with the consent of the occupier, based on the occupier's gratuitous permission and not for any business purpose. The plaintiff in this case was held to be a licensee and not an invitee. And applying the principle above, yeah. So the defendants were found liable as the cause of the injury, which was the projection of a rock in a tunnel, was concealed danger as was known or ought to have been known by the defendant. Okay. Jadi this is the case that illustrate on this. And then lastly, we have an entrant by implied permission, you know, implied license. So they are the one who enters premises in circumstances di mana the court implies a license. Maksudnya the entrant, they enter the premise in a situation where the court implies a consent, ada consent. Yeah? This is a question of fact. Okay. You can refer to the case of there's this one case, yeah. You boleh refer to this case. I forgot the name of this case. This case of Laurie against Walker. Okay, this is the case of Laurie against Walker. I forgot the year, yeah. If I'm not mistaken, it's quite old case, yeah, but I'm not sure the year, but this is the name of the case, yeah, Laurie against Walker. Where in this case, if you read this case, yeah, Laurie Walker, the defendant adalah occupier of a field, okay, occupier of a field. Jadi sepanjang beberapa puluh tahun, people there, they were accustomed untuk pass the field. Bila mereka nak pergi ke railway station, mereka akan pass the field, ya. And then after that, once the defendant occupied the field, the defendant erected notice untuk prevent entry. Jadi dia ada letak notice ya. Tapi even with the notice, the defendant did not bring any action against siapa-siapa yang still enter the field, because some of them were the defendant's customer. Okay. And then after a few years, if I'm not mistaken, after 15 years ya, defendant ada letak has put a dangerous horse ya, vile horse in that field without giving any warning ya. Jadi dalam kes ini the plaintiff was crossing the field, he was attacked by the horse and then suffered injuries. Okay. And because of the injuries, the plaintiff brought an action against the defendant. Jadi dalam kes ini, dalam kes Lori Walker ni, very old case in 1911, if I'm not mistaken, in 1911, the court said that there was implied permission of the defendant. Kenapa? Because the defendant did not even brought an action against those who enter the field. And this happened for a very long time ya. Jadi dalam kes ini, mahkamah kata the defendant was liable because there was implied permission or implied license given by the defendant. Maksudnya sebab ada implied permission ya. Sebab defendant tidak buat apa-apa, tidak brought any action, just allow people to enter into his melalui field dia untuk ke railway station. Jadi dalam kes ini mahkamah kata defendant was liable. Okay? Sebab ada implied permission. Alright? Okay, so that's on that. Okay. This is the important point. What are the factors? Okay, what are the factors that the court will consider when determine whether the occupier owes a duty of care towards the licensee? Maksudnya, apakah faktor-faktor that need to be considered for an occupier to be held liable to a licensee yang suffer injuries ataupun damage to his property? Okay. The two factors, as you guys can see here, first, the occupier's knowledge. Okay, maksudnya occupier knows about the danger ataupun ought to have known about the existence of the danger. Okay, so the term knows about the danger ni means that the occupier ni, they have the knowledge of the existence of the danger. Dan term ought to have known ni adalah jika kita letak other reasonable man, jika kita, who is put in the same situation as the occupier, whether they will have known of the existence of the danger ataupun tidak. Okay, so here it means that the occupier ought to have known of the existence of the danger. So this is the first point, occupier's knowledge, yeah. And then the second one, the existence of a concealed danger ataupun trap ataupun something hidden, yeah. So the licensees, they just has to prove that the danger is unknown to him, and because why it is unknown, because it is something concealed. It is concealed and could not be expected to happen. And he needs to prove that the occupier failed untuk warn the existence of the danger. So these are the two factors that will be considered, the occupier's knowledge and also the existence of a concealed danger. So if these two are proven, the occupier is said to owe a duty of care towards the licensee, and because he owes a duty of care, kalau kata berjaya buktikan other elements, then the occupier will be liable. Okay, alright. For example, you boleh refer kepada case yes, the same case, the case of Yap Ching Hock, the same case that we've discussed just before this. The plaintiff ni adalah geologist ya, dia visit tunnel untuk visiting ya, for his own purpose ya. Okay. Jadi dalam kes ini the court held that the plaintiff was a licensee because they entered the tunnel ya, after getting permission, and then the court held that the defendant was liable. Kalau you baca kes ni, the court held that the defendant was liable. Kenapa? Kerana first, the defendant, i.e. the occupier, the court said that the defendant has knowledge of the danger because the defendant was familiar with the condition of the tunnel. Okay, jadi mahkamah tengok facts, mahkamah tengok circumstances, mahkamah kata defendant ni tahu kewujudan danger tersebut ya. Jadi why? Because they're familiar with the condition of the tunnel. So the defendant must knew ataupun ought to have known about the concealed danger. Okay, and then second, why the court held that the defendant was liable? Because of the existence of the concealed danger. Okay, concealed danger. Sebab dalam kes ini, plaintiff dalam kes ni a geologist ya, dia tengah examine some rocks ya, and then the machine under the control of the defendant suddenly it started to operate tanpa warning ya, so it was concealed danger ya. And then the lighting also was inadequate and etc. You guys can read the facts of the case lah ya. And because of the defendant dalam kes ini was negligent for failure untuk warn the plaintiff of the concealed danger that was known to him. So it fulfill all the two factors that we've discussed just now, and because of that, the defendant dalam kes ini the occupier, the defendant was held to owe a duty of care towards the plaintiff. Okay, all right. So based on our discussion, we can say that an occupier owes a duty of care to a licensee. Okay, what's the duty? The duty is to warn the licensee of any concealed danger that he actually knew ataupun ought to have known. Okay, so that's the duty of care. Standard of care owed by an occupier towards the licensee. Okay, all right. And then lastly, the last one will be on trespasser. Okay, trespasser. The word trespasser itself most probably will be familiar to you guys ya. Trespasser, the person who enter premises without any express ataupun implied permission from the occupier ya. So a trespasser ni unlawful visitor lah, dia unwanted ya, and they enter the premise tanpa sebarang permission, tanpa sebarang contract, tanpa sebarang knowledge of the occupier. Okay, and it can be either by mistake ataupun on purpose ya. So they are not licensees, they are not invitees. Contohnya macam pencuri ya, a burglar enters into B house untuk steal things. So that person will be considered as a trespasser because he enters without any permission given. Okay. But the question now is, okay, trespasser for trespasser ya, whether an occupier owes a duty of care towards a trespasser because they are the person who trespass, yes, who enter without any permission or invitation. So whether an occupier owes a duty of care ataupun tidak. Okay, previously, as you guys can see here, previously, the answer is no. No ya, so occupier ni tak owe any duty untuk prevent any danger that will happen to the trespasser. Tak ada sebarang duty of care towards the trespasser. Okay, and this is based on the case of Robert Eddy. If you read ya, kalau you baca old textbook, especially old textbook textbook for example Winfield ya, by Winfield, it mentioned that general rule is that trespasser ni dia kena take the premise as he finds it. Jadi previously occupier ni takkan owe any duty towards the trespasser. Okay, tak perlu take any reasonable care ataupun protect the trespasser from any concealed danger. This is a previous position. Okay, but now occupier has a duty. Occupier has a duty to trespasser if the presence of the trespasser is known or reasonably possible. Okay, jadi ada duty jika occupier tu tahu kewujudan trespasser di premise tersebut ataupun it is possible that there will be trespasser. Okay, but bear in mind that the duty of care owed is actually lower compared to the duty owed by an occupier towards other entrants that we discussed previously, the three entrants ya. Jadi the duty adalah untuk warn the trespasser of the potential danger in the premise. Okay, Jadi it means that the danger is known to the occupier, and the occupier needs to warn the trespasser of any potential danger. How can he do that? How can he give warning? Maybe he can use notice, okay, ataupun put sign, ya, put warning, bahaya and everything. Katalah ada abandoned building or whatsoever. Kalau selalunya ada abandoned building ni, selalunya ada trespasser yang akan masuk abandoned building. So the duty of an occupier adalah he put some warning. Contohnya letak warning, kata bahaya, ada banyak barang-barang berbahaya, macam contohnya ada apa tu, batu bata ataupun benda tajam di building tersebut. Contohnya, ya. Jadi that's his duty. That's the occupier's duty untuk warn the trespasser of any potential danger in the premise. Okay. For example, you can read the case of British Railway Board 1972 case. Dalam kes ini, if you read the facts of this case, the case involved trespasser who was a 6-year-old child. So he entered a land owed by the defendant. Jadi dia step on the electric railway tracks. Okay, electric railway tracks. And because of that, they suffer injury. Dalam kes ini, mahkamah kata the defendants liable. Okay, and this was a 1972 case, yeah. So at that time, the court stated that an occupier did not owe a duty of care to a trespasser. Tapi kes ini is one of the case di mana mahkamah kata, the court started to held that an occupier does in fact owe a duty of a lower duty of care towards a trespasser, yeah. And the duty is to give warning to people, to those trespassers, to the person who might be on his premise. So in this case, even the plaintiff was a trespasser, the court held that the defendant was still liable. Okay. And if you look at the position in Malaysia, the test applicable in deciding whether an occupier is liable to a trespasser for loss or damage caused while on the premise is a subjective test based on the occupier's knowledge of the danger on his premises according to his own financial limitation. The general rule is that an occupier does not owe a duty to prevent dangers which has arisen without his knowledge. However, if the occupier knows or ought to know that a trespasser may enter his premises, then the occupier must take reasonable precaution to avoid any damage from occurring. This is the position in Malaysia. So maksudnya still ada duty, but it's lower duty untuk warn the trespasser of any possible danger that might happen at the premise. Okay. All right. That's about trespasser. For child trespasser, the general rule is principle in an occupier must accept that children are less careful as compared to adults. The safety of children to a large extent lies on their parents, and therefore an occupier has the right to question this responsibility or lack of it. If the warning given to him are considered sufficient, this is the principle as stated in British Railway Boards. Yeah, sama juga, kiranya samalah position child trespasser. Yeah, you can also read the case of Lembaga Elektrik Negara, Malaysian case. Dalam kes ini involve a child trespasser. And the respondent dalam kes ini adalah berusia 10 tahun, budak lelaki berusia 10 tahun. He climbed a pole, a pole erected and maintained by the appellant, Lembaga Elektrik Negara. Dia climb tu sebab dia nak release a bird that was trapped on the wire, yeah. But unfortunately, he was electrocuted and he suffered severe injuries. Okay, so this case went up to the federal court, and the federal court held that an occupier only owes a duty of care to trespasser if he knows that there is a chance that they might be trespasser come to the place. Okay, jadi maksudnya based on this case, we can say that the occupier owes a duty if he actually knew the trespasser presence in that premise or knew that the trespasser might present. Okay, first. Second, if he actually knew the condition of his land ataupun premise which akan likely untuk cause injury to trespasser. Maksudnya he aware of the existence of the danger. Dia tahu keadaan dia punya premise tu berbahaya untuk orang luar datang masuk, ya. Jadi these are the two factors that will be considered by courts. Ya, jadi mahkamah dalam kes ini refer to these two factors. Okay. Alright. So that's about child trespasser. Okay, lastly, so we already discussed all these types of entrance, yeah, and the standard of care required of of an occupier towards each of different entrance. Okay, now defenses. Defenses, yeah. Um, there are these certain defenses that can be raised by the occupier, including first we have voluntary non-fit injury and also notice, yeah. Meaning once the plaintiff proves the case against the occupier can raise either any of these two defenses or any other defenses available. Okay. For example, voluntary non-fit injury, we already discussed about this defense, yeah. Maksudnya no injury can be done to a willing person. Okay, no injury can be done to a willing person. So the rule is that plaintiff ni takkan ada remedy if he himself consented to the doing of the act that caused his harm. Ya. Jadi it is a complete defense. Jadi mahkamah kena decide sama ada plaintiff ni act ni adalah voluntary ataupun tidak by looking at the facts of the case and other evidence. Okay, and the burden of proof is on the defendant. Jadi defendant ni kena buktikan yang the plaintiff ni voluntarily consented to the act ataupun any omission even when he aware of the risk. Okay. Alright. Maksudnya occupier needs to prove to the court that plaintiff voluntarily consented to the act of entering into the occupier's premise when he fully aware of the danger. Okay, this is the first defense, or the defendant can also raise the defense of notice. Ya, maksudnya occupier ni boleh cakap bahawa dia telah put some notice in the form of warning or an exclusion clause or whatsoever. Ya, jadi this is the second defense that might be available to the occupier who has been found liable, yeah, for the injury happened to the entrant. Okay. So I want all of you to read these defenses. So these are all the important discussion for topic 12. Yeah. So if you get any question on this topic, first you need to determine who is the occupier. Okay, who is the occupier? And then you determine who is the occupier, and then you need to determine the categories of the entrance. Sama ada dia fall under any one of the four entrance. Okay, sama ada dia adalah sama ada the entrance adalah contractual entrance, invitees, licensees ataupun trespassers. Lebih bagus kalau you boleh in detail under which type, you know. For example, katakanlah first that person is a contractual entrance, and then you can further detail it, make it detail by determine whether it is main purpose entrance ataupun it is ancillary purpose entrance. Okay, something like that. So after you determine what kind of entrance that person is, then you need to look at what are the standard of care required of an occupier towards the entrant. Jadi you tengok sama ada telah breach, the occupier telah breach the standard of care required of him, and then you can apply it to the problem and make the conclusion whether you think that the occupier owes any duty of care towards the entrance ataupun tidak. Okay, so that's basically topic 12. The end of topic 12. I will end the lecture here. Thank you so much, everyone. Assalamualaikum warahmatullahi wabarakatuh.